Well, let's get started. Let me introduce our speaker for this morning. This is a two-part call. Our speaker today will be David Rusnick, who's with Drew Eckel and Farman. He is Forum, I should say, and he is a litigator extraordinaire and has a fair amount of experience in representing parties that are interested or have been contracted to be involved in arbitration. He'll make his presentation. I'd ask that you enter your questions in the Q&A comment, and we'll keep track of that. And then after that, I'll pick it up and we'll finish up the call today. Dave is going to talk a little bit about things you might want to have in your arbitration clause and some things to consider. And then when it comes my turn, I'll talk a little bit about maybe things that you don't want to consider. So Dave, the floor is yours.
Thank you, Sam. Good morning, everyone. As Sam said, I am a trial lawyer, a litigator, and uh, what I do in arbitration is actually litigate them. And more often than not, I am handed by my clients an arbitration clause. I'm handed a contract saying I have a problem. I have been sued. I want to sue somebody. Dave, go do it. And then I pull up the contract and I have a look and I see what am I working with and where am I going to be suing? Am I going to be suing in the courts, federal, state? Is it going to be an arbitration proceeding? And more often than not, I open up the contract and I look and find the ADR provision, and then I am suitably horrified because either it has been drafted by another party and is a real contract of adhesion, or my client has put it in and it's a single paragraph and it leaves out everything that I might need or want if I'm going to be representing them and I'm going to try to get them to a place where they've got a resolution that works for them. My presentation this morning is based on real world experience, things that I want or don't want in an arbitration clause. And if you're drafting them, or if I had the chance to draft them for my own clients, these are things that I would want to consider, I'd want to put in, I'd want to keep out. And this may overlap a little bit with what Sam is going to say here. But the basic subjects, and these are all real world experiences I've had in the last few years. And when I was putting this outline together, I really went back and looked at what I had, problems I'd run into, questions I'd had with arbitrators, things that had come up. And I'm just going to go ahead and list them before I dive into them. Uh, Setting conditions precedent, contractual conditions precedent, a mutual or unilateral contractual right to compel arbitration, venue for the proceeding, discovery rules that might apply to the proceeding, the governing law considerations, whether or not you want to have rights permitting or prohibiting joinder of related parties, class certification rights, scope of the arbitrable dispute. Sorry, it's still morning. That is one of the biggest issues we run into. The choice of whether we're going to be under the Federal Arbitration Act or the Georgia Arbitration Code if we have the choice. The choice of rules for arbitrating, what service, what rules within the services we might want. The choice of how we compose the panel and all the choices that go along with that. And the contractual right to appeal. A lot of folks out there are not aware, and I'm talking about trial lawyers, that there are contractual rights for appeal within arbitration. Prevailing party attorney's fees, the cost to be awarded at the end, and the ability to control those costs, who is going to be saddled with them and what can be saddled, or what you can be saddled with. Confidentiality of the proceedings, as well as the reasoned decision requirement. These are the subjects that have come up fairly frequently in the last couple of years in my arbitration practice. which I might add is becoming a larger part of my practice. More and more of my clients want to go to arbitration, but they want to go to arbitration under conditions where they have some control or they have the right to include various people, various things. Let's start with setting the contractual conditions proceeding to arbitration. The first thing that I see, and I do a lot of construction law, is whether or not there are going to be contractual conditions preceding things that have to happen prior to being able to either mediate or arbitrate. Oftentimes, you may want to have as a consideration that your clients have to meet with the other side, even preceding a or rather a mediation. This is a common first step in a lot of construction contracts. And it's something that if you are drafting an arbitration clause, even outside of construction, you may want to consider. Um, Also, there is the question of whether or not you want to have mediation prior to arbitration. This as a condition precedent. Uh, Not all contracts require it, and it's something that you may want uh, as a additional step after a meeting of principles. But it's also something that I think is the most common subject of motions to stay in federal court. Somebody goes directly to arbitration and they make a demand on one of the services, but there's a mediation requirement. If you want to perhaps slow the process down, give everyone a chance to sit and talk about it in a mediation, uh, that may be something you want to include. Or you may want to include the right to mediate, but not necessarily as a precondition. You may file the arbitration, but before you go to the actual arbitration hearing, there needs to be a mediation. And this sometimes is valuable, like in litigation, if you are going to want to have some discovery. Sometimes mediations without any discovery or any exchange of information, be it voluntary or through one of the processes, um, they don't work. So a mediation condition is something that you might want to consider as part of your conditions precedents to arbitration. You also may want to decide about time limits as a condition precedent. That is a private statute of limitations that someone has a year from an event in which to file for arbitration, or the arbitration rights are lost. This is an enforceable contract right, and unlike modifications to the statute of limitation under state law, where there are public policy issues in certain states, this is something that can be done by contract, and it's something to consider. You may not want an arbitration right hanging out there for the full 6 years of a simple contract. You may want it to have it for a year, but you're going to also face some reasonableness issues with that. So the first thing is, what is the condition precedent to getting into arbitration? The next thing that I would actually think about is who is going to control the right to arbitration? Do you want it to be a mutual right or a unilateral right? And this is something for your drafting. Do you want the right to control the forum? That is, do you want to make sure that they have to go into arbitration if you say so, or again, is it mutual? This comes up all the time. Somebody wants to arbitrate, but I don't want to arbitrate because I have a claim rising out of a contract, or I have some sort of a contract situation where I'd rather be in court. I'd rather be in federal court because I'm going to have a dispositive motion right. And that dispositive motion right may be very valuable. Whereas in mediation, you're going to find mediators, or rather in arbitration, arbitrators are often very reluctant to grant any sort of dispositive motion. They might not even have the contractual right to do so. That's, again, something that could be put into the arbitration clause. Now, you can structure this a number of different ways. You can have it as a mutual choice. You can have it as your unilateral right, or you can have it functionally as a veto, where you can veto the ability of the other party to compel arbitration. The back channel, or the backside decision here, is a control of costs. Sometimes you absolutely want to compel someone to go to arbitration simply because it's going to be far less expensive and far quicker. But there may be tactical reasons, and you want to consider these for your specific drafting when you're dealing with a specific client who has particular type of business where you don't want to necessarily let small claims be dragged into arbitration. They won't be worthwhile to the parties. So you may want to have the ability to veto those small claims, make them go into a magistrate court or make them go into a state court or somewhere anywhere but arbitration if you want to control the cost or you want to use the cost otherwise as a weapon. And that is another consideration. Uh, Litigators are always thinking about that. Now let's talk a little bit about venue. And venue is a big issue. And it's one that if you don't contract for it, you can get stuck under state law having the proceeding somewhere else, a place where the project exists or a place where the parties entered into the contract. The considerations here are, do you want the venue to be for your convenience or possibly the inconvenience of another party? I have an arbitration proceeding that's going to be going off in the middle of nowhere, Illinois. That's where the other party's headquarters are, and we are going to be in the middle of a cornfield in Illinois. I really want to arbitrate there, but that is what the arbitration provision provides, and it is very tactical on the part of that party to ensure that arbitration is going to take place in their hometown. If for no other reason, it really dampens down the desire to get into an arbitration. My client doesn't really want to spend a week or 2 weeks in the middle of a cornfield in Illinois. Again, this also impacts smaller claims. Does somebody want to go to the middle of a cornfield in Illinois to do a smaller claim? It may lead to settlement outside of the arbitration proceeding. Sometimes you want or need that home field advantage. And by that, I mean, are there going to be arbitrators that you prefer in that jurisdiction? If I'm in the middle of Illinois, am I going to be able to get Sam or somebody else I really want as an arbitrator to go to Illinois and sit in a cornfield for 2 weeks and arbitrate a case? Now, Zoom and other virtual formats uh, may prevent that as being a big problem or keep that from being a big problem, but it's something to be considered. Venue also needs to be considered, especially if you are under a state and not the federal arbitration acts. Can you get witnesses to the hearing? Can you get documents to the hearing? Can you compel someone to produce themselves or documents in another jurisdiction? This can be a expense. This can be a real problem to present in your case. You may be able to take a deposition. You may not, because depositions may be limited under by the arbitrator or by some form of contractual agreement. A good example of this is I'm currently arbitrating a matter here in Atlanta. My party is here in Atlanta, and their contract was written here, but the project, which was a federal project, was in Tuscaloosa, Alabama, and all the other parties are in Tuscaloosa. And if we were going to sue them, we'd be in Alabama, and we'd be looking at the Alabama rules on procedure, discovery, on joint and several liability, comparative liability. But because we had a venue provision in the arbitration that provided for it to be in Atlanta, dragging everybody here, I have the total home field advantage in that regard. And that's something when you're drafting, you need to be paying attention to.
Well, Dave, on your
Yes.
topic of Zoom calls, this is relevant to your Alabama conversation. You know, more and more people want to do these things on Zoom. And if you are intending to allow that, it's a good idea for you to put that in the agreement.
That is true, because that decision can be up to an arbitrator, and or you can contractually require that the arbitration be done in person if that's what you really want. Now, I don't know that I've seen that But if it's important to you that everybody be in person, that's something that needs to be in the agreement itself. I'm more concerned about getting witnesses to these events. Now, witnesses can be brought in by Zoom. That's, ever since the pandemic, we've had a whole lot of that. But there are some witnesses you don't want by Zoom. You want them in person. Their credibility needs to be attacked or needs to be shown to the arbitrators, something that the flat screen may not provide. And that's a consideration, especially for venue. Another consideration that I have seen a lot of is discovery. What are going to be the rules and what are going to be the limitations? If you leave it up to Sam or some other arbitrator, uh, they're going to apply their discretion, their judgment. They're going to look at the size of the matter. They're going to look at the complexity of the matter. They're going to decide whether it's proportional, something akin to what you might see in a federal case. But you may want to impose serious limitations on discovery by contract that Sam then has, or any arbitrator has to abide by. You may not want unlimited depositions. You may want 4 or 5. You may not want requests for admissions. You may not want unlimited requests for production of documents. The idea behind arbitration is and always has been that it is an effective, cost-effective, time-effective way of resolving disputes. And we have seen all too often in arbitration over the last 10 years that it's almost indistinguishable from litigation. Arbitrators are, if they're not contractually required to limit discovery, sometimes they're given the complexity of the matter to give a rather extensive discovery or third-party discovery or unlimited depositions. And if you want to control that and control the costs and control the time involved in getting to a actual hearing, the discovery will extend that time, then that's something that needs to be addressed in the discovery rules that you might add into your arbitration clause. And I recently in an arbitration in Dallas, there was a pretty good fight over whether or not a third-party discovery, we could get to records of a bank, whether we could get third parties to produce documents. And the arbitrator was having none of it. The arbitrator was a very traditional, old school arbitrator, and he was making sure that we stayed within the buoys. And so that cut off my client from some evidence that they wanted to present. If you want to have third party discovery or you want to prevent it, it's something to be included in the arbitration clause. If not, the contractor is going to have discretion. And that discretion is also going to be dictated by whatever service rules that you're using. Are you using AAA? Are you using JAMS? Are you using the complex, the construction, small matter? It's all going to dictate what Sam or some other arbitrator is going to think is reasonable, and that's what you're going to have. And you may not be able to get evidence that you need, or your other side may be able to drag things out and make things more expensive, or obtain evidence that you're not interested in them having. So that's another fairly important consideration of you want to be able to draft, or you want to draft for. Governing law considerations. This is a big one. I'm in this fight over and over again. I'm in this fight in that matter in Alabama. The Alabama lawyers keep saying the project was in Alabama, so Alabama law controls. I'm like, no, we're having it here in Georgia. That's where the venue controls. That's where we are. That's where the contract was signed by us. And so Georgia law applies. Now, Georgia and Alabama tort laws are very different, and there are negligence claims involved in that particular dispute. Other things that you're going to want to think about when you're setting your governing law: statutes of limitations, statutes of repose. Does your client want to be under a 6-year statute or a 2-year statute? These are things you need to be thinking about. Are there preferable apportionment rules under the state you're choosing? Will there be joint and several liability issues? If not, apportionment rules don't control, or if you get into that inextricably intertwined body of case law where you can get to joint and several liability even though you have multiple parties who might be in the arbitration. you might have several who are going to be liable, but only one who can pay. And joint and several liability might be a big issue there. You want to draft for that. Um, there are also considerations of state law statutes you definitely want to avoid. And you need to be very careful when you choose your jurisdiction. An actual case in point is a matter I arbitrated, must be 20 years ago, where it was a construction matter, and the opposing attorney, who was licensed in Georgia and South Carolina, rather cavalierly decided South Carolina law was going to apply. And he sat back and smiled at me and said, "Well, paid if paid, we haven't been paid. Your arbitration can't go forward." And then I proceeded to tell him about the South Carolina Subcontractor Payment Protection Act that had been passed the year before, or 2 years before, which provided that paid if paid was statutorily abrogated, that they were obligated to pay whether or not the owner had paid them. And that was their best defense, and turned out to be not much of a defense, as my client went on to get a rather substantial award that would have been avoided if he had simply allowed Georgia law, or the law of the place of the project, to be the controlling state law. If you have an arbitration agreement you're drafting and it's going to be a contract that's going to apply over multiple states, do be careful. You need to be thinking about that, because that can come back to bite you in a hurry, especially on prevailing party attorney's fees. And I'll talk about that a little bit later. Um, Other considerations for state law, I mean, are there public policy issues that you're going to run into? And you need to be thinking about that when you're drafting. Are you trying to shift negligence or responsibility for sole negligence? In Georgia, in certain construction and engineering matters, OCGA 13-8-2, you can't shift sole negligence. Other states, you might be able to. Public policy, you need to be considering that. And again, you might want to be careful about governing law, because governing law may have certain jurisdiction or venue provisions that you may want to avoid, or you may want to rely on. These are just things to consider when you're drafting the provision. And let's talk about joinder rights. You need to be considering that. Specifically, do you want the arbitrator to be able to compel related parties, such as subcontractors or sub-subcontractors in a construction matter, or vendors, or people who have related rights, to be a part of the arbitration if there is some sort of an indemnity or contribution issue? If that is contractually limited, you may not be able to reach those people, or you may want to avoid a state law provision that is going to limit your ability to have the arbitrator bring those people in. And this is, again, especially important in arbitration, and when you're looking when you have indemnity or contribution provisions, that you need to make a part of this arbitration, or you need to bring people in because of those provisions. Another jointer right issue is, do you need to engage other people for insurance coverage? Thinking about the context, especially in construction. Do you need to bring in everybody who walked across the construction project, because they all have carriers, and you need to get enough pockets together to make sure that you can either settle the matter in arbitration or in mediation, or you have enough pockets at the end of the day to solve the problem. The other thing about jointer rights, and this is something I have seen on a number of occasions, is, do you have a political or business problem you need to avoid? You may want to contractually set up your arbitration provision so that someone who's important to you, someone who feeds you business, someone who you don't want to make angry, doesn't end up in that arbitration with you, or having to spend money or time or agitation, or possibly incurring liability because they haven't been cut out of the arbitration. They may want to only be in the courthouse. They may not want to be in an arbitration provision. And if you're not protecting yourself, or rather protecting those people, you may find them unhappy. And that's a real provision. That's something you really need to be considering when you're drafting. Something you don't see too often, but you may want to consider it depending on what business you are drafting for. Class certification considerations, especially under the FAA, you can have a class arbitration. You may not want that. And you may want to have waivers in your contract or in your arbitration provision to avoid class certification. That's going to be tied to and controlled by the language in the contract in your arbitration provision. Um,
Dave, that's a question we see a lot. And one of the things to be mindful of is where your arbitration is going to be. Some states don't really allow or disfavor those limitation of class actions, and some are neutral towards it. So it all goes into what you're drafting and what you're doing. And you see it a lot in the consumer construction cases.
and again, that goes back to choice of law and venue. Uh, Now, something else I'm sure Sam sees more often than not is the scope of what can be arbitrated. Uh, and this is I see this fight just about every big arbitration. The Federal Arbitration Act creates a presumption that you can arbitrate matters, and that's been confirmed over and over again in the 11th Circuit. But at the same time, the 11th Circuit will say that no party can be forced to submit to a dispute or can be forced to submit a dispute to arbitration that he or she did not agree to arbitrate. So you get into that fight right there. But here's the kicker. You need to be very careful about your writing of your clause because there are ways you can get dragged in, even if you have not agreed. Under There's a particular 11th Circuit case. It's Employers Insurance of Wausau. It's a 2001 case. And in that case, it talks about non-signatories can be bound to the arbitration agreements of others. These theories arise out of common law principles of contract and agency. They include incorporation by reference. And these in construction contracts are the flow up and the flow down clauses, where you're bound to what, say, might be between the owner's contract and the general contract or the prime contract. Your contract may relate up to those contracts, and all of a sudden you're in arbitration. They can be done by assumption of contracts, by agency principles, piercing the corporate veil, alter ego, and they can even be done by estoppel. There are principles by which a non-signatory can get dragged into an arbitration that you don't want to be in or your client doesn't want to be in. And you should be thinking about that when you're drafting your arbitration clause. Be sort of specific, especially when it gets to the flow up and the flow down clauses.
Related to that, Dave, there's a number of cases that come up where you've got a construction defect coupled with an injury claim. So if you have a contract that is written up that really deals with the construction defects, that's one thing. But there have been some cases where people have died due to some of these defects. And the question becomes, are you going to arbitrate those claims also? And the courts have generally held you need some evidence, some language in there that says to the court, we intend to arbitrate all the claims, including tort claims and personal injury claims.
Sam, you're spot on. And you actually just hit a piece of my outline.
Oh, okay.
2 sections down, but no, that's absolutely something that you need to be considering. But the first consideration when you're looking at scope of what will be arbitrated is who do you want to have decide what is going to be arbitrated? Do you want the arbitrator to have the authority to decide, or do you want that to be left to the courts? The case law is that unless the party clearly and unmistakably provide otherwise, the question of whether the parties agreed to arbitrate is to be decided by the court, not the arbitrator. And that is a U.S. Supreme Court case from 2002. That's the AT&T Technologies case. That said, most of the courts will say that a lot of the courts are saying that arbitration, the right to decide who will be or what will be arbitrated is delegated to the arbitrator, where the arbitration rules authorize the arbitrators to decide on their own jurisdiction, the arbitration rules, that is. So if you designate arbitration rules, and those rules, be they AAA, JAMS, or one of the other services, that give that right to the arbitrator, and that's part of your contract, by incorporation, you have now given the arbitrator the right to decide what will and will not be arbitrated. If you don't want the arbitrator to have that right, if you want to reserve that to the courts, you need to be careful. You need to draft around that. Um, so your considerations here are: do you want an expansive or a limited scope for what's going to be arbitrated? Do you want to keep it tight, or you want to just have everything that all the problems that you have with the other party made a part of this? Do you want to be able to exclude matters that are not part of the contract scope directly, but might involve related projects or related contracts, and have sort of a global lawsuit where, as in a court, you can bring in, any claim you might have against that party? If you want that, that's something you may want to provide for. Do you want to be able to bring claims in that are going to engage insurance coverage? Do you want to be able to exclude insurance coverage so as to disincentivize certain parties from bringing arbitrations? Uh, as Sam said, do you want tort claims, death claims? Do you want fraud claims? Do you want negligent misrepresentation claims? Do you want those in where they're tangential to the contract? You want claims that are going to be, how do I want to say this? You want claims that are going to uh, involve torts that are not involving a contract duty that's been violated. All these things are to be considered based on your own client's business and how your client, or where your client, is going to be doing business. Do you want the arbitrator to have the ability to grant equitable relief provided by state or federal law? Do you want them to be able to grant specific performance or injunctive relief, or do you want to reserve that for the courts? These are things that all need to be looked at. And if you have a opinion, or your client's business is going to be served by one or the other, that's something you're going to want to put in your arbitration clause. According to the 11th Circuit, because parties are free to structure their arbitration agreements as they see fit, they may limit by contract the issues which they will arbitrate. And that is a 1997 course, American Express Financial Advisors versus Markowitz. And as always, I'm running out of time. Choice of whether you want the FAA or the Georgia Arbitration Code, the Federal Arbitration Act, that is. You may not have a choice. The Federal Arbitration Act preempts the Georgia Arbitration Code or any state code if you're dealing with interstate commerce. But if you're not, you can actually elect the FAA, and you can do so by contract. And you might want to, because the Georgia Arbitration Code is going to govern unless you designate the FAA. Now, that gets down to what are the benefits of having the FAA, even if there isn't interstate commerce? Well, the biggest that I'll say right now is the ability to subpoena witnesses and documents from outside the state, because the Federal Arbitration Act is generally considered to have extra state, interstate reach. Georgia Arbitration Code will not allow you to bring a witness from outside the state or bring documents from outside the state, because Georgia is right now not a party to the revised Uniform Arbitration Act, which would allow subpoenas between states that recognize that act to be honored in either state. So what act
So,
is going to cover it needs
so
to be
they,
considered.
how do you get somebody if you want to, if you're under Georgia code and you want to get a witness there, how are you going to handle that?
Well, you can have an arbitrator issue a subpoena if it's within the state.
Okay, outside of the state. So your Alabama case, for example, what do you do?
If I wanted to get a witness from outside the state into the court in Georgia, I'm going to either have to go outside the court and depose him by agreement, because I can't subpoena him
Right.
if he's outside the state, unless there are unless it's under the FAA, and then I can use the federal courts to enforce a arbitrator subpoena. But if it's within the state and Georgia is not a party to the new act, I'm not going to get that witness unless by agreement I can go out and depose the party because I can't enforce a subpoena. I mean, I can say I'm going to go depose somebody in Alabama, but that person doesn't want to show up. And how do I compel them to show up? I can't subpoena them. I can only do it by agreement. And that, in the Alabama case, since the Alabama parties are over there, we went over and we took depositions over in Alabama. And then we took Georgia depositions over here by agreement. But I would have had a big problem uh, getting to a deposition over in Alabama, and I would have been looking at possibly cross-examining somebody blind here in arbitration because I wouldn't have been able to depose him if it hadn't been done by agreement. Another consideration that you might want to think about. Um, just sort of briefly, I know we touched on this a little earlier. Choice of rules. Do we want to cite the AAA rules? Do you want the JAM rules? Do you want one of the other half a dozen organizations that have rules? One of the private organizations here, some of them, the private services here have their own rules or modified rules rising out of the AAA. Uh, you might also want to be designating rules within the services. AAA, for instance, has commercial, complex, construction, and small matter. You might want to designate one of those because they have differing discovery rights and obligations and different timeframes and different panel compositions or how panels might be chosen, which is sort of the next subject. And that is, do you want to control what kind of a panel you have? Do you want a one-party panel? Do you want a three-party panel? Do you want a party pick? Each party picks one, and then those two arbitrators pick a true neutral in the center. How you want that done? What the panel is supposed to how the panel is supposed to be comprised? That's something you need to control within the agreement if it's important to you. One of the big reasons why you're controlling the panel is cost considerations. And Sam and I were talking about this the other day. If you have a matter where it's a couple of $100,000 at issue, but now you have three arbitrators, all of whom are going to be participating in a reasoned decision, you may run up a heck of a bill on a fairly small matter. You may just want one arbitrator. So that's a consideration that you need to be giving some thought to. And I mentioned this before, contractual right to appeal. I can't tell you how many people are almost flabbergasted that you can actually contract for the right to appeal in arbitration. AAA, JAMS, and other services have arbitration appeal rules and rights. You can designate that in your contract. Usually it's a panel of three, and they have to render the decision within 3 months of the appeal being filed. They can vacate, they can modify. And if you've got a client who's reluctant to be in arbitration because there's no appeal right, this is a big concern. Now, you want to think about this because there is no automatic right to appeal under certainly state or federal law in arbitration. And you have limited grounds by which you can appeal. In a state case, you've got corruption, fraud, misconduct, exceeding the arbitrator exceeding authority, failure to follow procedures of the FAA or the GAC, or manifest disregard of law. If you're contracting for arbitration, you are probably going to have a much more amenable standard, such as material or prejudicial errors of law, as opposed to manifest disregard. Or you can attack clearly erroneous factual determinations if the arbitrator just didn't get it right, or you think they didn't get it right. So if you want to control broader appeal rights, or you want to have any appeal rights at all, or the ability to modify an award beyond what's provided for by, say, the Georgia Arbitration Act, which I think is 9914, these are things you might want to put in your arbitration clause, because you can actually stipulate to arbitration after an award if you want, or actually it may be before. No, it's after the award. But if you're the only party who's gotten an award, if Sam's given my client everything they want, and we don't have a cross appeal, not going to stipulate to an arbitration. If each party has cross appeals, they think the arbitrator didn't get it right in some regard, each party thinks that, then you might have a stipulation. But if you want to guarantee the ability to appeal, if you think you've got an issue where you might need that, that's something you need to be able to put into your arbitration agreement. And it's something that I know a lot of carriers, insurance carriers, would like to see because they get really itchy about there being no right to appeal if a single arbitrator makes a unfortunate ruling. Um, let's see how much time I have left. Yep, I've got about 5 minutes. Let's talk about prevailing party attorney fees. Uh, they are permitted if you provide for them by contract, or if you can get to them under statute. Now, in Georgia, we don't have contractual right to attorney's fees, but this actually goes back to the choice of law. If you're in a state such as Texas, where under the Civil Practice Remedy Code, Chapter 38, if it's a contract matter, there's statutory fees for prevailing party. You need to be careful about your state law, which is governing. Uh, because if you don't contract for them, you're not going to get them, and the arbitrator can't award them as part of the cost. Now, this is something which can be fairly tactical. If you want to ensure that you have the ability to get your fees back if you have to arbitrate, you want to put it in your agreement. But if you're not so sure, you want the other side to be really interested in arbitrating because they can't get their fees back, that's something you might want to admit or omit. Um, Costs to be awarded by the arbitrator to the prevailing party. If the parties agree to an allocation, then the parties' agreement will control. If not, it's up to the arbitrator. Georgia law is pretty clear about that. Couple of the last two things I really would like to talk about are confidentiality of proceedings. If you have something in your arbitration that you don't want out in the public, you need to provide for that in the arbitration provision. Now, Sam is held as an arbitrator to being confidential, but that doesn't apply to witnesses. It doesn't apply to parties. And if you're going to have a confirmation of an award and there is a reasoned award where there are going to be facts that might be sensitive or something you just don't want out in the world at large, you need to provide for that because once that award is confirmed, that reasoned award is probably going to be out there for everyone to see. And I have an arbitration in Texas. We got a very good award. We got the arbitrator to terminate a covenants not to compete because they violated Texas law. And that's now been confirmed. That's out in the world, and we're able to hold that up every time the disgruntled opposing party mumbles about we're breaching their agreement. Well, no, we're not. And here's the public document that says we're not, that you lost. This is not enforceable. You can contractually agree for it, and if it's important to you, that needs to be in your agreement. The last thing I think I really want to touch on, because I'm pretty sure I'm running out of time here, Sam, is
That's okay. That's
reason.
okay. There's no trap door underneath your chair or anything like that, so we're good.
Oh, good to know. Reasoned decision requirements. This is something you want to control as well. Do you want a reasoned decision? Do you not want a reasoned decision? Reasoned decisions can be very helpful. They can be very expensive. They can be very hurtful too if you're on the wrong side of one. And they also impact your ability to appeal. Because if you don't have a reasoned decision and somebody does try to take an appeal up to a appellate panel within, say, one of the arbitration services or out to the courthouse, if there isn't a reasoned decision, too bad. You're out of luck. If you think you might want to have appellate rights, either within the service or in the courts, you need to have a reasoned decision. Again, this interplays with the confidentiality provisions. And but More often than not, it has a lot to do with cost. If you have a 2 week arbitration, and now Sam is being asked to sit down and sort through all of that. It could take him 30, 45, 60 days, and it could be tens, 30, $50,000. If it's a horrible case and Sam's time is completely committed to this for a month. Things to consider. Um, I've run through the top 15 or 16 of my issues, Sam. Are there any questions that anybody would like to have me address, or do I simply turn it over to your part of the program?
Let's do that. We'll monitor the questions and try to answer them if any of them come up. Okay.
All right, then.
Um, I think on the topic we just were, I think we'll talk about that for just a second. And this wasn't in my outline, but um, the bulk of my work is as an arbitrator. I do a little bit of mediation and I do a very small amount of advocacy work, but almost all of it is arbitration. Um, and I have learned over the years that having a reasoned award is good for the process because, and what I never announce my decision from the hearing at that time because I really want to go back and go through all the evidence. And I find that the part of writing up the award and making sure that my decision uh, is there is really, really important. And I allow, when I'm budgeting my time, I allow about a half a day for every day I've been in hearing. So there, it does add some cost to it. I just did a 8-day hearing and I literally allowed 4 days to write the award. And it takes every bit of that from me to do it because I want to go back and look at it all again. It never turns out quite like I think it would. So I've learned to kind of do that. Um, and Dave is right. If you want to have any chance at having an appeal, you need something more than just an award. So the basic award is I fine for the claimant or I fine for the respondent any amount of X. That's kind of an award. Reason award is more detailed. If you haven't seen one of them, it typically lays out the reasoning why I might would fine for one party or another. It might be a credibility question. It might be a failure to prove. It might be any kind of different things. Um, it might be something that some of the issues were raised were outside of the scope of the arbitration. So those are things that are really, really important. The other thing I would point out in drafting these clauses, I know Bay and AAA both have clause drafting tools available for you. And I don't believe they charge anything at all for that. You can log on to it and it'll go through a series of questions and ask you what you want to cover. It's very worthwhile, at least as a starting point. I'm reminded of when I initially started practicing, I had a real estate practice and I asked a friend of mine, how did he draft covenants? And he said, well, come with me. And we went back in his office and he opened up a file drawer and it had probably 200 sets of covenants. And he says, pick one you like. Well, that's kind of the way that a lot of times you'll find arbitration clauses are drafted. So one of the reasons that we're talking to you all about this is so that you understand what's going on and what you might want to do. The other thing I would caution you about is not to get too carried away on the strange items because it may prevent you from retaining an arbitrator. If you get too carried away and you're outside of the normal course of things, the arbitrator may look at that and go, I don't know, I don't know if I want to get involved in that. So just food for thought. So back to Dave's comments here. Let's go back to the basics. You've got to have a written agreement to arbitrate something. And it's just that simple. Georgia Code 993 says that. However, we see a lot of cases where parties can't find the agreement to arbitrate, and it's not unusual at all. I know in the AAA world, they'll send somebody a piece of paper and each of them will sign it, and it'll be about one paragraph. It says, we agree to arbitrate our claims. And that's all you really need. It doesn't have to be fancy. But as Dave points out, you may not be getting everything that you really want to. On the subject of it being in writing, I've had at least one case where somebody wrote on the arbitration agreement, no, and that came up before me. And there's another relatively famous case that says no refused. So that's not an arbitration agreement in writing. You have to be able to look at that. That raises an interesting topic. And I'm sure that many of you all have seen in today's times the browse wrap or the click wrap agreements. I've had a number of them come before me. Um, and that's an agreement just the same. But there's a caveat to that. And there are some cases, there's an 11th Circuit case holding that the consumer or the person signing the click wrap agreement would have to know that he's signing an arbitration agreement. In other words, it can't be buried in there in the middle of nowhere. So, in that case is Valiente versus IEC US Holdings. It's a January 24 case. Um,
Sam,
yeah,
would you tell some of these folks what a click wrap agreement is? Because I don't
click
know that
wrap.
everyone knows.
Okay. Um, that's a great question. Thank you for bringing it up. A click wrap means you go to engage some services and it says click here and then sign. That's a click wrap. A browse wrap is it's built into it and you merely by browsing, you've agreed to that. You can see the enforcement problems that would come up with that. Uh, the Court of Appeals held in the case I just cited to you that a consumer in Valiente's position would not have known to review the terms of use as he was never directed to them and never asked to represent that he had read them. So if you're drafting stuff like that, and we see it in service contracts, engineering contracts, inspector contracts, those kinds of things, you need to make sure that from a third party perspective that you've really covered the topic there. Um,
Well, Sam, less on engineering contracts because they never read their contracts.
well, that's a great point because about 99% of them say our liability is limited to the amount that you paid us. And if you do that, I mean, if you do that, the courts generally have upheld that as long as it's otherwise enforceable. Of note, the ending of forced arbitration of sexual assault and sexual harassment acts prevents certain things from being arbitrated. It doesn't prevent everything between an employer and employee, but it does mean that they can't force an arbitration of a sexual harassment or an assault claim. I'll take the opposite position of Dave for a second and say that, as you might expect, that limitations on discovery are typically something that you want to have in an arbitration clause. And the reason is that, what I find is that, the discovery process in not all, but many cases is less about discovery and more about, wearing somebody down. And so, if you're faced with 10 or 12 deposition requests, I find that most lawyers understand that this is an arbitration is designed to be cost effective and, they try to limit that. But there's, for example, there are telephone consultations, there are interviews that are not transcribed. There's a number of things that can be done to get around that, but we don't see that many depositions. I would encourage you to have that. Likewise, imposing time limits helps the arbitrator keep the case on track. AAA, and I'm sure JAMS has a fast track provision. And what that says is that you're going to get a preliminary hearing within 30 days or so, typically, and you're going to go to an evidentiary hearing within another 30 to 60 days after that. The parties can typically waive those kinds of provisions, but keep in mind that you're committing yourself if you're putting one of those in. If you're asking the case to be tried under a fast track provision. In AAA, the fast track provisions typically apply to smaller cases. There's usually a dollar limit on it, but it's something for you to consider. I want to talk for a minute about there's a case called Hooters versus Phillips. It's out of South Carolina, and it involves some sexual harassment claims. No big surprise there, and it was before that act occurred. But what happened was the employer engaged in such a limiting set of rules that the court found the overall arbitration provision to be unconscionable. and did not mandate the arbitration. It also has some indications for what you've got to do with class action. Now, it comes out of South Carolina, so it's not totally applicable here in Georgia. One thing I would caution everybody to do is not to name an individual arbitrator. I've seen a few of those, and that would be a reason why, for example, if it came to me and it says that Dave was going to be the arbitrator, no offense intended against Dave, but I can't do it, so I have to say no. We see some cases where they want the arbitrator to be a member of the bar. That sounds good in theory, but in time, businesses typically these days work over various multiple jurisdictions. I just had a case where the requirement was for the arbitrator to be a member of the Florida bar, but the case arose out of Alabama. Presents an interesting dilemma. Just be careful with what you do that. And as Dave mentioned, when you pick a panel of three, and that's done typically because somebody's uncomfortable with what the arbitrator would do. So they say, well, we'll do three panel. We'll each appoint one, and the two of those will appoint a third. I've got two of those going right now, and they're each of them less than $1 million cases. And we're going to spend as much in arbitrator fees as we're going to spend in the damage award, I suspect, but we'll see. So what kind of things would get the arbitrator or the award knocked out? 9913 lays them out for you. That's under Georgia, but federal law is very much the same. One, corruption, fraud, or misconduct. Okay, that's pretty obvious. Two, partiality of the arbitrator as a neutral. We all try to maintain our neutrality of it, but as the law says, an overstepping of the authority or an imperfect execution can cause the arbitration award to be kicked out. Arbitrators manifest disregard of the law. Those grounds are typically have to be asserted timely. In some cases, it's 20 days, depending upon which statute you're working on. In some cases, it's 90. So you need to take a look at that. One of the big things that we see is that a valid agreement to arbitrate was not made. And David, we talked about this in our conversation earlier. There's a fairly famous case out of Florida where the home builder required the clients to arbitrate their claims. Gentleman involved parked his car inside the garage. Someone inside the house succumbed to the exhaust fumes, and the court held that arbitration clause did not go so far as to include that. Number one, it didn't mention any kind of torts or anything like that. One thing to be concerned about is that the courts do enforce, and the arbitrators do, the statute of limitations. We see a lot of it again in engineering contracts. It says you got to bring the claim within a year. Why might that be the case, Dave? You know anything about that?
Because we don't want to deal with them.
Nah.
After
many of the insurance coverages are related to time, and whether you have a reporting or an occurrence clause. It can create an artificially short time period. So you need to make sure that if your client has insurance, and many do, you need to make sure that that's going to be covered under that. And that's why you see some artificially short deadlines in those cases.
You're also facing construction matters, Sam. I'm sorry. In construction matters, when the job is underway or there are matters that are going to need to be decided, say, prior to closeout of the job, you want these things brought quickly before the money goes away, before the carriers say that you have not timely reported, or you end up from your perspective, if you have a claims made versus an occurrence contract, insurance contract, you wait too long, and now you're in a period of time where you have a whole different insurer.
Yeah. Or maybe they
who
don't
hasn't
buy
rated
tow
for that
coverage.
risk.
Yeah. And of course, if it's a professional liability, it's a little bit different band there too. Overstepping authority. The arbitrator could exceed the powers, and that's, for example, granting relief when they don't have the power to do so. It's always a touchy subject. Manifest disregard of the law, where the arbitrator is aware of the law or deliberately chose to ignore it. Certainly, that's there. Um, so let me go back and talk a little bit about other items that might be problematic. Um, Collective bargaining agreements between employers and labor unions are generally not favored or allowed. Um, Arbitration of insurance claims typically are not allowed. Um, if it's a consumer financing agreement and the amount is less than $25,000, that's not generally subject to arbitration. Although, again, these things that we say are not subject to arbitration, if both parties agree, it can be arbitrated. An agreement to arbitrate future claims arising out of bodily injury or wrongful death as a result of a tort. That's under the Georgia Code. Um, any contract relating to terms or conditions of employment relating to the cause of agreement to arbitrate must be initialed at the time of the execution of the agreement. So that clause has to be initialed at that time. Sales, and this is a big one that'll catch everybody. Sales agreements that are for the purchase or financing, right? Sales agreement or loan agreement for the purchase or financing of residential real estate that clause must be initialed by all signatories. We
That
see,
one comes up a bunch, Sam.
yeah,
I've seen that time and time again.
it does. And it comes up in part just because of the logistical problems with getting it used to be not a big problem when we all used paper forms and things like that, but today everything is done on digitally. And so you got to make sure that that's been done and been initialed.
Yeah, Georgia Association of Realtors was real hot to get that one
Yeah,
passed.
yeah. Well, that's true. Although I'll tell you, we see a lot of those cases, and in particular, we see a lot of home improvement cases, and so all that stuff gets tripped into there. Um, so I think that's the things that I want to talk about right there. Do you have any questions, Dave? And I don't see that you
I
have any.
go back over a couple of things that you said and sort of amplify them. Um, the services that have these clause building programs,
Mhm.
they're great, but you have to stop and understand the law of unintended consequences. That sounds great. Yeah, I'm going to click that. I'm going to put that in. And if you haven't spent a relatively good amount of time understanding your client's business model, the kind of litigation they are going to get into, the places they're going to be litigating, if you have a client who does business across the South or nationwide, you, you that list of 15 things or 16 things I rattled off, that's probably half the list of things that you could actually consider. And if you actually go out and look at the body of materials, papers, law review articles about what is and is not subject to arbitration, it gets down to incredibly granular level. Sam told me I had 45 minutes. I'm like, great, I can put a 6 hour presentation into 45 minutes if I talk really, really fast. So again, if nothing else from my perspective, it's you have to think through. If you have the opportunity to write one for your client and you're not like me, just getting it handed to you and say, here you go, Dave, I hope it works. You need to spend a fair amount of
Yeah.
time thinking through these things. I mean,
On
there are
that
other
top on
things.
that topic, before you change, I think it's a really good practice to take your arbitration clause and hand it to somebody and say, "Look at this for me." And it's just time well spent, because there's always another viewpoint on there, and you shouldn't get too wrapped up in it. I'd want If I was drafting that clause today, I would call Dave and say, "Take a look at this and tell me what you think," because I know he's going to have a different viewpoint.
I can also go into the case law reporters and pull up, you know, various arbitration cases and look at all the things that have blown up. And from the litigator standpoint, I'm always fighting the last war. What blew up last time? What failed what caused my client consternation that they didn't consider before they signed that agreement? Again, it's the law of unintended consequences. There are states that might require an arbitrator in some instances to be a licensed attorney, but not all arbitrations need to be done by attorneys. There are captive organizations which are captive to industries that tend to be named, and you get people who are arbitrating who haven't the first idea of what they are doing other than they're protecting their industry. And if you
Well,
run into one of those,
on that point, Dave, I talked to somebody the other day who was from New Jersey and was saying that in New Jersey, I don't know whether this is true or not, but in New Jersey, if you're arbitrating a home construction or a construction case, you have to be a licensed professional, as in an engineer or an architect, which I can see
and
how that would come about.
especially if there's some sort of a defect case. Now, and Sam, I don't know if you've seen this or not, but there are religious courts who can be named as arbitrators. And if you do it by contract and you give them the power to render a decision and you designate whatever religious body or doctrine or dogma is going to govern, you're stuck.
Well,
That's
and I have seen one of those. I've seen a case where they appointed the pastor of this church to resolve any differences they had. And the pastor, I don't know who was consulted about it in advance, but of course, it turns out that two of his parishioners were having a fight with each other. It involves some pretty good money. So where does that leave that fellow? I mean, if he may not be comfortable in making those decisions, or
or
should he?
there are conflict of interest questions that arise under those circumstances.
Yes.
Because that pastor owed a fiduciary duty to each of his congregants.
Yeah.
So, I
Yeah.
mean, all the questions just go on and on and on, all the things that you might have to consider, but it all rolls back to the idea that you have to know what it is. If you have a chance to draft, what your client's business model is, what's their business, what kind of disputes are they going to get into? And, when you have to hire Sam or you have to hire me to argue in front of Sam, what are you going to arm me with? What are you going to keep me from having that I really, really want? I mean, there are times I've just walked in and handed the contract back to the person and said, I can arbitrate this, but I'm going to be doing it hopping on one leg with both of my arms tied behind my back because you won't let me go this place. I mean, I've arbitrated claims where I've been told I cannot third party in key witnesses because they're tied to politically or business sensitive situations. I can't bring that person in. I have to prove what that person knows, and maybe that person is the only person who knows it. But
Well,
I've not had my hands entirely tied.
on that topic, and Dave mentioned this a minute ago, they call them flow downs. Typical construction contract says that we have the right to bring in our subcontractors to participate in this litigation if there's a dispute arises. And then typically the subcontractor agreement says that we agree to participate in that. That's the flow up clause. Um, it all does you no good at all if the client gets only the construction contract done, but not the subcontractors done. And I've had that case come up recently where uh, the miscreant involved, they never got to sign a contract. And he's the person that caused all of the problems. Poured a slab, it was wrong. No contract that had any arbitration clause in it. So it really makes it difficult. And now you're going to litigate this case in state court or federal court. Um, yeah, I think you have to think about the purpose of arbitration is to resolve disputes timely, fairly, and economically. Last thing I want
That's what
to,
the arbitrators say.
yeah,
The litigators think
yeah,
about it from the other direction.
that's right. Well, and one thing I want to mention is everybody has a thought process on using one of the arbitration houses, AAA, jams or whatever, and they say the cost is too much. But if you do not, and I've got a case where they call it a pro hack case where I'm it. Um, the problem with doing away with those clauses is those people that do that work provide a valuable service that I don't, that you're otherwise paying me my hourly rate to do. So be careful when you say, I don't want to do it with whoever. And there's a number of them. I'm on panel with several of them, but there's always a cost involved in it. And it's always work. And it's about the same amount of work whether I do it or somebody else does it. So it's worthwhile to be that. And then the rules are very, very complicated. And you know, I'm on three houses, and the panel rules involved are very complicated. So I just encourage you to get to, if you're, as Dave says, if you've got somebody that's in the, you know, the oil and gas business, for example. I don't do much work in that. That's a specialty in and of itself. Construction is a specialty, employment's a specialty, and all of those typically have very specific rules.
That brings up another subject, and that is, again, the choice of panels. Um, Sam comes out of a construction background. And so, and for a long time, he was in-house with a major builder of homes, as I recall. So there's a certain body of knowledge there. And certain panels are going to have people on them who are going to have more knowledge about the particular subject. And if you're designating a service or a panel, you want to be giving some thought to, are you going to get somebody, perhaps like Sam, who has a deep body of experience in that particular area, where you can go to particular arbitrators? Or are you going to end up having to get someone who has general business knowledge? Now, that person probably will do a fine job, but they're not going to understand the nuances when you're making your arguments. Some of this, and I do a fair amount of real estate too. And years ago, I think I had a chance to try a case from the business court. I think we might have Judge Inazonian. We may have the judge on, and he'll recall how wickedly complicated and archaic the real estate law was that was underpinning that case.
Well, and
Um,
I'm glad you brought that up. I think one of the first cases I tried, a guy built a multi-million dollar house here in Atlanta, and the foyer was, it had this rotunda in it. It had this circular floor, and they imported some sort of wood from Africa, and it was supposed to be cut on a radius. That is, each piece was supposed to be curved. Well, the guy they hired to do it um, had less than the required skill set. Let's just say that. And so he hand cut, not computer cut, but hand cut all those curves in this. It was a fairly large room, and of course, it looked like what you might imagine. When we tried the case, we were lucky enough to get an arbitrator that had extensive flooring experience, and he knew how that was supposed to have been done, and he knew how, you know, what it would take to make those curves to get the radiuses right and everything. You know, it really does make a big difference having somebody there that understands what the work is.
a couple of other things, Sam, you raised, and I thought I might just go back over a little bit, or at least expand on them. In addition to appeal rights, the right to vacate an award, there are rights under the Georgia Arbitration Code to modify
Yep.
if a arbitrator is given a complex set of business damages and they calculate them to be $1 million and it should be two or half a million. There are, I think, is it a 9913 that allows for a request to be made to the Court of Appeals to modify, or is it, or
Actually,
is it, I'm
actually,
sorry, it's the trial court.
yeah, it goes back to the arbitrator. You know, you file a motion that says, you know, the math is wrong. You know, in clause number two, you said $1 million in clause, and in the summary total, you used $2 million or whatever. And that comes up a lot in construction cases because there's some fairly complicated math in those claims. So yes, and that has to be brought fairly quickly. See if I can find it in my notes here. It is. I believe it's under 9913. And what you do is you bring it back in front of the arbitrator, um, and you just file a motion. On a related topic, Dave, one of the things, and we don't see it a lot, but I know under AAA and I assume under JAMS, there is a procedure for an emergency hearing. And you can ask for that if you've got, like, for example, the construction case that you mentioned a minute ago, Dave, where you've got something that's ongoing. If you need an arbitrator appointed for an emergency hearing, you just file a request and ask for it. I was involved in one about a year and a half ago, and the arbitrator got appointed like in 2 days, and the case went to hearing in 5 days. Um,
If you have the right service designated, if you can get, if it's in the arbitration agreement, again, it's, is there the possibility that you might need some sort of emergency relief? And if you don't have the, uh, the right rules designated within the arbitration clause itself, you're not going to get to that relief. Um, by the way, the judge who tried that case is on the panel. He just sent a little message to me. And that was a case where we were doing some truly arcane real estate rules. And our judge in that case was quite helpful, but also at one point, I believe he commented that he hadn't seen some of this stuff since law school. So when you're picking an arbitrator, by analogy, you need to be sure that you're picking somebody who actually has that skill level and
yeah.
understands that subject. And you might want to provide for that in the arbitration selection process if you have a specialty item that you're going to be arbitrating. The one last thing I did want to talk about, because we are starting to run out of time, and there may be some questions. And you mentioned this in terms of overstepping authority. That's really a due process question. And if you end up, and that's the basis of that, if you end up arbitrating something that you did not have the authority to arbitrate, Sam, you would never do that. But if somebody did, and that goes up to the court, for confirmation or for you want to appeal that, that really is a due process issue. And I honestly, I won a civil case in Texas 30 years ago on civil due process because the judge decided to dismiss claims that were not subject to an arbitration. And that judge got reversed by the Dallas Court of Appeals in Texas on civil due process. And I'll give you all $1 for every other civil due process case that you can show me rising out of arbitration.
The Phillips versus Hooters has a long discussion about civil due process in there. But it takes a lot of reading to get to it.
They're not too often.
Yeah, that's right. Not too often. So let me open up the floor for any questions. Does anybody have a question? Okay.
We stunned them.
Yeah, well, that's great. Well, I'm glad to hear that. Thank you, everybody, for their time today. Thank you for participation, and thank you for coming.
I think we have applause coming up here. That's what
Yeah,
those are.
yeah,
Thank you for the applause.
yeah. Thank you. So we appreciate everybody being here, and I think with that, we'll sign off.